Data is the pollution problem of the information age, and protecting privacy is the environmental challenge. Bruce Schneier. The Personal Data Protection Act, 2018 is a bill incorporated to regulate the processing of personal data of individuals, by government and private entities incorporated in India and abroad. This will be called Personal Data Protection Act, 2018 and extends the whole of India. The Act is passed in the Parliament Winter Session 2019. Where is this applied? The Act applies wherever within Indian territory data is collected, stored, disclosed, processed. This includes any state, Indian company, Indian citizen, person or body of persons incorporated or created under Indian law. This also applies to processing of personal data by fiduciaries or data processors not present within India. Let us understand the actors of this Data Privacy Act. Data fiduciary means any person, including the state, a company, any juristic entity or any individual who alone or in conjunction with others determines the purpose and means of processing of personal data. Data principal means the natural person to whom the personal data is referred. Data processor means any person, including the state, a company, any juristic entity or any individual who processes personal data on behalf of a data fiduciary, but does not include an employee of the data fiduciary. Let us understand the sensitive personal data that falls under the Data Protection Act. The data are categorized as passwords, financial data, health data, official identifier, sex life, sexual orientation, biometric data, genetic data, transgender status, intersex status, caste or tribe. Let us understand the obligation under the Data Protection Act. Any person processing personal data owes a duty to the data principal to process such personal data in a fair and reasonable manner that respects the privacy of the data principal. Personal data shall be processed only for purposes that are clear, specific and lawful. Collection of personal data shall be limited to such data that is necessary for the purposes of processing. Personal data and sensitive personal data shall be processed only on the basis of one or a combination of grounds of processing in a lawful manner. The data fiduciary shall provide the data principal with the necessary information, no later than at the time of collection of the personal data. The data fiduciary shall take reasonable steps to ensure that personal data processed is complete, accurate, not misleading and updated. The data fiduciary shall retain personal data only as long as may be reasonably necessary to satisfy the purpose for which it is processed. The data fiduciary shall be responsible for complying with all obligations set out in this Act in respect of any processing undertaken by it or on its behalf. What are grounds for processing personal data? Personal data or sensitive personal data may be processed on the basis of the consent of the data principal. The data fiduciary shall bear the burden of proof to establish that consent has been given by the data principal for processing of personal data. Personal data or sensitive personal data may be processed if such processing is necessary for any function of Parliament or any state legislature. Personal data may be processed if such processing is necessary for the exercise of any function of the state authorized by law. Personal data may be processed if such processing is necessary to respond to any medical emergency involving a threat to the life or a severe threat to the health of the data principal or any other individual. This also includes sensitive data, passwords, financial data, health data, official identifiers, genetic data, and biometric data. Personal data may be processed if such processing is necessary for recruitment or termination of employment of a data principal by the data fiduciary. The personal data can be processed for reasonable purposes like interests of data fiduciary like prevention and detection of unlawful activity, whistleblowing, mergers and acquisitions etc. Grounds for processing personal data for children? The data fiduciary shall process personal data of children in a manner that protects and advances the rights and best interests of the child. Appropriate mechanisms for age verification and parental consent shall be incorporated by data fiduciaries while processing data for children. Guardian data fiduciary shall be barred from profiling, tracking, or behavioral monitoring of, or targeted advertising directed at, children. Data principal rights. The data principal shall have the right to obtain from the data fiduciary confirmation whether the data fiduciary is processing or has processed personal data of the data principal. The data fiduciary shall provide the information as required under this section to the data principal, in a clear and concise manner that is easily comprehensible to a reasonable person. Where necessary, having regard to the purposes for which personal data is being processed, the data principal shall have the right to obtain from the data fiduciary processing personal data of the data principal. The data principal shall have the right to receive the personal data related to the data principal in a structured, commonly used and machine-readable format. The data principal shall have the right to restrict or prevent continuing disclosure of personal data by a data fiduciary related to the data principal. Transparency and accountability measures. Privacy by design. Every data fiduciary shall implement policies and measures to ensure that managerial, organizational business practices and technical systems are designed in a manner to anticipate, identify and avoid harm to the data principal. The data fiduciary shall take reasonable steps to maintain transparency regarding its general practices related to processing personal data. The risks associated with such processing, and the likelihood and severity of the harm that may result from such processing should be evaluated, and the data fiduciary and the data processor shall implement appropriate security safeguards. Personal data breach. The data fiduciary shall notify the authority of any personal data breach relating to any personal data processed by the data fiduciary that may cause any harm to any data principal. Data protection impact assessment. The data fiduciary intends to undertake any processing involving new technologies or large-scale profiling or use of sensitive personal data such as genetic data or biometric data, or any other processing which carries risk of significant harm to data principals. Such processing shall not be commenced unless the data fiduciary has undertaken a data protection impact assessment in accordance with the provisions of this section. Additionally, the data fiduciary shall maintain accurate and up-to-date records. The data fiduciary shall have its policies and the conduct of its processing of personal data audited annually by an independent data auditor under this Act. The data fiduciary shall appoint a data protection officer providing information and advice to the data fiduciary on matters relating to fulfilling its obligations under this Act. The data fiduciary shall only engage, appoint, use or involve a data processor to process personal data on its behalf through a valid contract. They shall not further engage, appoint, use, or involve another data processor without the authorization of the data fiduciary. The data processor, and any employee of the data fiduciary or the data processor, shall only process personal data in accordance with the instructions of the data fiduciary, unless they are required to do otherwise under law, and shall treat any personal data that comes within their knowledge as confidential. Classification of data fiduciaries as significant data fiduciaries are based on volume of personal data processed, sensitivity of personal data processed, turnover of the data fiduciary, risk of harm resulting from any processing or any kind of processing undertaken by the fiduciary, use of new technologies for processing, and any other factor relevant in causing harm to any data principal as a consequence of such processing. Grievance redressal. Every data fiduciary shall have in place proper procedures and effective mechanisms to address grievances of data principals efficiently and in a speedy manner. Every data fiduciary shall ensure the storage, on a server or data center located in India, of at least one serving copy of personal data to which this Act applies. The central government shall notify categories of personal data as critical personal data that shall only be processed in a server or data center located in India. Personal data other than those categories of sensitive personal data, the transfer is made subject to standard contractual clauses or intra-group schemes that have been approved by the authority. The central government, after consultation with the authority, has prescribed that transfers to a particular country. The authority approves a particular transfer or set of transfers as permissible due to a situation of necessity. Exemptions. Processing of personal data in the interests of the security of the state shall not be permitted unless it is authorized pursuant to a law and is in accordance with the procedure established by such law, made by Parliament. Processing of personal data in the interests of prevention, detection, investigation and prosecution of any offense or any other contravention of law shall not be permitted unless it is authorized by a law made by Parliament and state legislature. The exemptions also applies wherever disclosure of personal data is necessary for enforcing any legal right or claim, seeking any relief, defending any charge, opposing any claim, or obtaining any legal advice from an advocate in any impending legal proceeding. And wherever processing of personal data is necessary for research, archiving, or statistical purposes. Additionally, this act is exempted wherever personal data processed by a natural person in the course of a purely personal or domestic purpose. Personal data is necessary for or relevant to a journalistic purpose. Personal data is processed through means other than automated means by a small entity. Who is the authority? Established and incorporated by the central government, the authority to be called the Data Protection Authority of India. The chairperson and the members of the authority shall be appointed by the central government. Penalties. Where the data fiduciary contravenes any of the following provisions, it shall be liable to a penalty. Penalties for discrepancies in obligations 5 Cr or 2% of annual turnover, whichever is higher. Penalties for discrepancies in processing 15 Cr or 4% of annual turnover, whichever is higher. Failure to comply with data principal requests, 5K per day subject to maximum of 10 lakhs for significant fiduciaries and 5 lakhs in case of others. Failure to furnish reports, 10K per day subject to maximum of 20 lakhs for significant fiduciaries and 10 lakhs in case of others. Failure to comply with directions issued by the authority, 20K per day subject to maximum of 2 crores and in case of data processor 5K per day and subject to maximum of 25 lakhs. Penalty for contravention where no separate penalty has been provided, subject to a maximum of 5 lakhs. Any data principal who has suffered harm as a result of any violation of any provision under this Act, or rules prescribed or regulations specified hereunder, by a data fiduciary or a data processor, shall have the right to seek compensation from the data fiduciary or the data processor. The central government shall, by notification, establish an appellate tribunal to hear and dispose of any appeal from an order of the adjudicating officer. Offenses. Any individual person or person in charge in a company or central or state government departments who alone or jointly with others, knowingly or intentionally or recklessly, in contravention of the provisions of this Act obtains, discloses, transfers personal data or sensitive personal data to another person, sells or offers to sell personal data or sensitive personal data to another person resulting in significant harm to a data principal. Then such person shall also be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Thanks for watching.